Welcome to the Probate Nation. My name is Richard Ruddy. Probate is a process to transfer the title of probate assets to the beneficiary of a deceased person. To do so, you may have undertaken to get yourself duly qualified to probate those assets. And that authority works well for probate assets located in the state where the decedent resided at the time of their death and probate was initiated. Unfortunately, that authority does not automatically extend to probate assets in another state, such as real estate from a prior home not yet sold, or ski condo that was a second home as well. That authority can be acquired, however, through a process called Ancillary Probate Administration in the state where the assets are located. In the show tonight, we will learn the nuts and bolts involved in undertaking an ancillary probate in Colorado, from how to initiate, steps to be taken after qualification, and how to wrap up that ancillary probate. With us is a Colorado attorney who will share his expertise and guidance on this topic. Our guest is the managing attorney at the Blake Harris Law Firm with offices in Denver, Miami, and Los Angeles. His practice focuses on wills and trust, asset protection, probate, and cryptocurrency. And he's often quoted on these topics on ABC, NBC, CBS, and Fox News, and newspapers like the Denver Post and Market Watch. Super Lawyer magazine named him a rising star in 2020, 21, and 22. Please welcome attorney Blake Harris. Hi, Blake. Welcome back.
Richard, great to be back on the show. Thanks for having me.
You're very welcome. I appreciate you taking the time again. Let's talk about this ancillary probate. Tell us, what is an ancillary probate?
So ancillary probate simply means that another probate has already opened up in another state, and then that probate needs to access property in the state of Colorado. So you're going to file a probate in Colorado and let the court know that another probate has already begun in a different state. That's why it's an ancillary probate. It's ancillary to the primary probate that's going on in another state.
So what assets typically need to be probated in Colorado by a non-resident decedent estate?
So it's typically real estate, because a bank account can be accessed from other states in most circumstances. Most banking that goes on is with national banks, but it's typically real estate. The individual died in Florida, and they owned a condo up in the mountains of Colorado. In order to transfer that property legally, you need to get approval from a Colorado probate court.
So who typically undertakes to initiate and handle the ancillary probate in Colorado? Is it going to be the person that's qualified in the home state of the decedent, or would it be a local Colorado attorney?
So the probate itself, it does not need to be done by an attorney, though I would recommend using an attorney at any time you're dealing with the court system. As far as who can be the personal representative, you can be an out-of-state personal representative. You don't have to be a Colorado resident. So if you're already the personal representative of the estate in California and you need to open ancillary probate in Colorado, you can be the personal representative, and you can do so along with the guidance of an attorney, but you can be the personal representative without being a Colorado resident.
Okay. So what court, we talked about courts that oversee, so what court actually would oversee a Colorado ancillary probate?
So it is the county in which the property is located would be the one to oversee it. So it's the county court, and every county has a probate division of their county court. The only county that has its own court just for probate would be Denver. Denver has a separate probate court. Otherwise, your local county judge would be the one to overlook any probate matters.
When you were with us last time, we talked about the various options for probating, but what are the options for an ancillary probate?
So for ancillary probate, just like a regular probate, for an ancillary probate, just like a regular probate, you have the option for formal or informal probate. I'm going to confuse the issue a little bit and mention the small estate affidavit. Small estate affidavits can be used if there's no real estate, the total value is under $70,000.
Okay.
Because ancillary probate typically covers because ancillary probate typically covers real estate, small estate is off the table. So for ancillary probate, you can open it informally or formally as well.
Okay, so We talked about the common ancillary probate, and we talked about the fact that typically, if you're doing an ancillary probate, it's going to have to be either an informal or formal because we're going to be dealing with real estate. That's what typically we run into for ancillary probates. So what is filed with the probate court or the court itself, if there's no probate court, to initiate an ancillary probate in Colorado?
So in order to initiate a probate in Colorado, you need to file the death certificate, the will, the application of the personal representative, as well as the court order stating that you've already been appointed the personal representative in another state. So it's the same thing as a regular probate, but you also have to file the paperwork stating that you've already been appointed, showing that you've already been appointed the personal representative in another state.
So in the case of the will, we would submit a certified copy because the original would be up with the home state, I assume.
Correct. A certified copy would suffice. Should suffice.
And so again, one that I think is very nice about Colorado, there's not really typically going to be any court appearance required. Is that true?
Correct. Colorado does not require you to appear at any time during the probate process unless there's a conflict. If there's a conflict in a hearing, maybe an in-person court appearance may be necessary, but otherwise you can complete probate without stepping foot into the courtroom.
Okay. And so we file our paperwork, and it takes a couple, 2-3 weeks for the court to issue our certificate of authority of be a personal rep or letters of administration?
Exactly. It takes a few weeks for the court to issue the letters of administration.
Okay. If it turns out that somebody does not need to do any probate in their home state, so the only place they got to probate is Colorado, then they would just bring all the original will, the original death certificate, and they would file that in Colorado to probate those assets. Would that be true?
Exactly.
Okay.
Right.
Okay. So what can be done with since real estate typically is what's going to come up in ancillary probate, what can be done with real estate once the ancillary probate has been initiated and you're issued your authority to act?
So as soon as you have your authority to act, you can sell that probate. I'm sorry, you can sell that property. As soon as the court assigns you the letters of administration in Colorado, you can turn around and you can sell the property the next day. Now you need to hold up on distributing those proceeds until any creditor period has expired, but you have the ability to sell the property right away or to take control of the property, kick out any tenants, evict any tenants, and improve the property for the purpose of maintaining its value. You can't add a pool to the property, but you can fix leaky pipes so that the property can be maintained.
Okay. So much like in any other probate, let's talk a little bit about the duties of the ancillary administrator. So what kind of duties do they have, or does that person have?
So the duties of an ancillary administrator are the same as those of a regular personal representative or an administrator. They need to submit to the court an account and an inventory of all the assets. They need to notify creditors through a newspaper publication if it's been less than a year since the decedent passed away, or actually less than 8 months because the creditor period is going to last 4 months anyway. So if it's been less than 6 to 8 months since somebody passed away, you'll need to file a newspaper publication. You then need to settle any debts. You can either pay them, dispute them, or settle them, and then you'll need to distribute the assets and finally file closing paperwork. And you can close an ancillary probate formally or informally.
So we talked a little bit when we did the earlier show on Colorado probates. Tell me a little bit about the creditors and we want to just kind of make sure we touch base with that, though. You know, there is a notice for creditors that has to be posted in the paper. Is that correct?
Correct. So in order to satisfy the creditor requirement, you either need to wait 1 year after the decedent passed away. At that point, creditors are forever barred from staking their claim. Or you can run a newspaper advertisement giving creditors an opportunity to step forward and stake their claim. And that then shortens the period from 1 year down to 4 months.
Okay. And the ancillary administration, frequently, a lot of folks don't get around to doing that until several months has passed in their probate in their home estate. So it wouldn't be uncommon, I suppose, for folks not to show up in Colorado till over a year has passed since the person passed away. Has that been your experience?
Yes, you're absolutely correct. If that happens, then what I would recommend doing is maybe not running a newspaper advertisements. If already been about, let's say, 6 months since let's say an individual passes away, it takes a few, 5, 6 months to, uh, it's not until 6 months later that you start the ancillary probate process. The letters you don't receive for another 30 days. So now you're 7 months in. I'm going to tell my client, let's not bother running the newspaper ads, because all that's going to do is get us until 11 months since somebody passed away. Let's just wait out one extra month and hope that the lack of newspaper publication doesn't cause any unknown creditors to come forward.
Okay. Now, and again, with the ancillary administration, we do have an obligation to file an inventory, and I think you mentioned that.
Yes. With ancillary probate, you still need to file an inventory to the court. The court will want to know what assets are in the Colorado estate.
Okay. Now I'm going to turn to creditors. So we have a little bit of time here to talk about, is the publication, there is a publication requirement. Okay, is that something that is statutorily prescribed as far as what the publication is supposed to say?
Yes. There's certain requirements that basically state the name of the individual who passed away, their date of death, and then contact information for the personal representative or the personal representative's attorney, so that you can contact, where to send contact information so that you can state your claim.
And is that one of those forms that's available typically on the court website to tell you what the publication should look like when you take it to the paper?
I'm not exactly sure whether there's a form for the newspapers. However, if you contact the newspapers, they're familiar with the process, and then they can give you guidance on what needs to be filed. And then there's a form that we file where we state what the newspaper publication included. And when you file that with the court may reject it if it's not done properly.
Okay.
And then you can also look up the statute as well for what needs to be in that notice.
Okay. Well, we really don't want to encourage lay people to start getting into the statutes. I think that is prescription for potential problem. But the papers are familiar, and of course, if it's not done correctly, the court will say it's not done correctly, and you'll do it again. So that's good to know.
And then the newspapers are familiar. The newspapers are familiar with the process.
And again, if there is a claim filed by a creditor, they file it with the local court where the ancillary probate is being administered. And then what does the administrator or the ancillary administrator do about that claim?
So they have the opportunity to either just pay the claim, or if it's not a legitimate claim, they can try to argue that they should not have to pay it, or they can just offer a settlement and say that, I know that this individual owed $10,000. Would you take $6,000 because now it's in probate? And we don't, if accurate, you could say we're not sure if we're going to have enough money to pay all the creditors, or you could say that it could be a very long time before we have money to pay the creditors. And most creditors will negotiate when it's time to, if the debt is being collected through a probate case.
Okay. Let's talk about wrapping up an ancillary probate. How is the probate closed? How is that ancillary probate closed?
So an ancillary probate can be closed in the same way that a regular case can be closed, either formally or informally, and it's irrelevant of whether the ancillary probate was open formally or informally. So you'd simply file the appropriate paperwork to close it formally or informally, and then the court will release you as personal representative. And after a certain period of time, there will no longer be an opportunity to come back and object to or hold you liable for anything that occurred.
Okay. And typically, I know you mentioned that for a regular probate, it might take 12 months or so. What's the time frame normally for an ancillary probate from beginning to end, typically?
So pretty similar processes. I mean, when I speak to clients, I tend to try to manage expectations, say about a year. Generally, though, when an ancillary probate comes to us, a lot of the information gathering has already taken place, and we can get through the ancillary probate a little bit faster. So more like 6 to 9 months as opposed to around a year.
Okay.
But again, Colorado is going to require ancillary probate be open a minimum of 6 months.
Well, let's talk a little bit how we can plan, how people can plan to avoid an ancillary probate. So I think the first thing I'd like to get a handle on, and I think folks want to know, is what is it typically going to cost, roughly, to undertake and do an ancillary probate in the state of Colorado?
So an uncontested probate is probably going to run about $3,000 to $5,000. If it's pretty simple, beneficiaries are getting along. There's not a lot of real estate to be liquidated. You're seeking professional guide, and you're receiving good advice. It's probably going to run around $3,000 to $5,000.
Now, typically, again, we talked about ancillary probate often involves real estate. So what could be done to avoid this ancillary probate of real estate with the real estate itself? What techniques are available?
So pre-planning, an ounce of prevention is worth a pound of the cure, and this is certainly true in the estate planning world. By creating a revocable living trust before you pass away and putting your property into a trust, that property will avoid probate. You can also use what is referred to as a beneficiary deed or a transfer on death deed, where you sign and record the deed prior to your passing away. And then after you pass away, your beneficiaries can take that deed or can take that property, take title to that property without going through the courts.
Now, you mentioned about recording, conveying the property into your revocable trust, and we're going to get to that in a second, but that really means they have to actually do a formal document and then take it to the land records and record it, correct?
Correct. Prior to your passing, you need to sign a beneficiary deed and record that beneficiary deed.
Right. It's important to know because some folks think they can simply list the property as a part of the exhibit to their revocable trust. That doesn't get that property into your trust. I think that's important for you to mention.
You're absolutely correct. That's a common mistake, that you can list something in your trust. It doesn't matter what your trust says. It matters what the property says.
Sure. Now, in the case of tangible property, there's probably not a lot of ancillary probate of tangible property, but I guess we could have cars or boats or maybe ski mobiles, that might be near the ski lodges. Do you see those assets being probated as well in an ancillary probate?
They can be, but for those assets, typically they're valued under $70,000, and you can just use a small estate affidavit to transfer them.
Okay. Good. Well, of course, one way to avoid ancillary probate in Colorado is to relocate to Colorado. Okay, and so a lot of folks, may have homes out there that are second homes and decide to relocate to Colorado, but they've done estate documents in their former residential state. In case, let's just say it's Virginia. If I show up to, and I want to kind of break these down by document, if I show up to Colorado and I have a Virginia revocable trust, okay, are you going to be able to help me with that Virginia revocable trust since it's based on Virginia law?
Yes.
Okay.
Yes. I mean, every state has to give full faith and credit to the laws of every other state. So in the same way that if you go to Vegas for the weekend and get married and you move back to Florida and you want to get a divorce, a Florida divorce attorney can divorce a Vegas marriage. So a Colorado trust attorney can administer a Virginia trust.
So let's just say I want to make changes to my Virginia revocable trust, but I now live in Colorado. Do you need to change the governing law in some way so we can make that work since you're a Colorado attorney and not a Virginia lawyer?
So any amendments would need to be done under Colorado law.
Sure.
Yes.
And you can restate it to make Colorado the governing law in the document. Is that correct, typically?
Correct. And we would. Now, some attorneys are hesitant to amend other attorneys' work and may require you to create a new estate plan. But yes, it can be done. That amendments can be made under new laws.
Okay.
Under new states.
If I show up with a Virginia pour-over will, again, I have a revocable trust, I have a Virginia pour-over will, is that something that I need to update as well when I move to Colorado and make Colorado my home?
Not necessarily. I mean, if you're making a different amendment to it, then yes. But simply because you change states, you don't need to create new estate planning documents.
Okay. And let's talk about the other two important documents that I would have typically done or folks would have done, which is my financial power of attorney. Written under Virginia laws, citing Virginia statutes. I show up to Colorado. Should I update or should I replace that with a Colorado power of attorney?
So by law, you don't have to. In practice, it would probably be wise to, because it's very common to get the runaround when you purchase, when you use a power of attorney. And if you're using an out-of-state power of attorney, the chances that you get a hard time using it definitely increase. So by law, you don't technically have to create a new power of attorney, but I definitely would recommend one because it's more likely to work if it's if it's written under a format that people locally are more used to accepting and using.
Okay, and the same thing goes with my medical decision-making document. Again, written under Virginia law, has all the typical citations. I didn't show up to a Colorado hospital. I'm now a resident of Colorado, and I present them with my Virginia healthcare power of attorney. How's that going to go over?
Same situation as the financial power of attorney. Technically, it will be accepted, but you're going to have a higher probability of success if it is written and signed under local law.
Okay, so what I think I take away from this conversation as I relocate to Colorado and decide I want to ski every day, that I really need to make sure I definitely probably should update my financial power of attorney and my healthcare decision-making document. My will probably will be okay, but we should have a lawyer take a look at that. And the trust, if I want to make any changes, I need to be prepared for the fact that I may need to restate that trust so that basically it becomes an amendment of the entire document so that I can get Colorado now as a governing law, because the lawyer there in Colorado has no idea what Virginia law provides, and he's going to want to get Colorado as a governing law. Do I have that as a correct?
Yes, and just to put it simply, Richard, if you move to a new state, contact a local estate planning attorney and have them review your documents, and they'll be able to guide you as to whether anything needs to be changed.
Sure. We have a few minutes. Let's get you sort of your final comments and your lessons learned. For people that are have to do an ancillary probate in Colorado, some of the things that you would tell folks to be careful about or otherwise would advise them to do.
Mm-hmm. So number one, be very considerate about how you want to handle creditors. You may want to run an advertisement in a newspaper to shorten the creditor period, but for ancillary probate, it's often better just to wait the 1 year after an individual passes away before distributing the funds, and that'll avoid the need to run an advertisement in the newspaper and cause more creditors to pop up. And remember, any creditor who pops up, you can usually negotiate a settlement. So don't be quick to pay any debt in full. I would always recommend trying to negotiate any settlement. And number two, there's a lot of pitfalls, a lot of landmines in the probate world. Definitely consider working with counsel. As I mentioned on the previous show, often clients will end up starting probate on their own, thinking it's going to be a pretty simple process. They come into some complication where it gets mishandled. Then they bring in a legal counsel, and the attorneys have to charge a lot more than they would had they then the family ends up paying a lot more legal fees than they would have paid had they just sought proper guidance from the beginning and guided in the right path.
Oh, I think that's very good. That's very good advice. We're reaching the end of our show now, Blake, but I want to, on behalf of the Probate Nation, again, I want to thank you for taking the time to visit with us, for sharing us both an overview of ancillary probate in Colorado and your advice as to what to do if that probate is necessary, and some of the things to avoid. And of course, this is valuable information and really a great public service for those viewers faced with the need to initiate an ancillary probate in Colorado. So thank you very much for taking the time to visit with us again.
My pleasure, Richard. Thanks for having me on the show. It's been fun.
You bet. Without a doubt, probate can be complicated and time-consuming. And this is especially true if you need to probate assets in another state through a process called ancillary probate. Many non-residents of Colorado own second homes in Colorado, especially homes on or near ski resorts. In our show tonight, we introduced you to the process that will need to be undertaken should you need to probate that Colorado second home. While the process seems consumer-friendly, I would be remiss if I did not emphasize the importance of consulting with local Colorado attorney about any ancillary probate you may need to initiate. The guidance of an experienced professional will help you avoid unnecessary work and pitfalls for the uninformed, while shortening the time you ride the Ancillary Probate train through the snowy mountains of Colorado. I hope you found the show helpful, and remember that replays of this show and all shows to date can be viewed on the Probate Nation website and soon on the Probate Nation YouTube channel. This brings us to the conclusion of our show. On behalf of the Probate Nation, thank you for visiting with us.